Well, good afternoon, everyone, and thanks for joining us today for another Australian Business Lawyers and Advisors webcast. My name is Kate Thompson and I'm Associate Director in our Newcastle office, and with me I have Tamsin Lawrence, who's an Associate Director from our Melbourne office. And today we're going to be talking to you about the somewhat vexed, controversial topic of NDAs and workplace sexual harassment. Are we going to be telling people not to use them? What's the vibe, Tamsin?
I think we're going to cover what they are first. And I think there's a bit of disagreement about what are we actually talking about. We use the term NDA, the government, the regulators maybe use it in a bit of more of a loose way. So we're going to cover off on that. We're then going to look at, well, can we even use them? And some of our...
It's a fair question.
Some jurisdictions are looking to maybe make it a bit tougher or put some restrictions. We're then going to look at how to use them properly. Or give it some tips from us, right? What to actually do. And then we're going to look at a few decisions from the courts, which also might teach us a few lessons about how to use them and what to not do, I suppose, in terms of how not to get yourself in trouble and how not to have them enforced by the courts.
Well, that's always our goal really in this space, isn't it? Staying out of the courts. Lots of media attention on this area as well. And I think, as you alluded to, some potential changes in the legal landscape, but still a lot of, conversations and considerations that need to be had at the workplace level as well. So quite a complex context and range of factors that we're going to be covering off today.
Absolutely. Well, should we get started?
Let's get started.
Great. So understanding non-disclosure agreements. We're going to kick off with what actually is an NDA. As you can all probably imagine, if you've been watching any kind of US legal drama, you would have heard the term NDA. It originates from an American concept in terms of protecting trade secrets. It was used in things like, protecting the Coca-Cola recipe and the KFC 7 Herbs and Spices recipe. But obviously now we're talking about in the context of sexual harassment complaints. Now, basically, they're a method of settling a workplace complaint outside of the court system, often without actually substantiating any particular type of behaviour. And you can use them for multiple different types of behaviour or for various different things in the workplace, but we're obviously talking about it expressly in the context of sexual harassment. And that's probably a nice lead in to mention that obviously we've discussed many a time, and we've done a webinar here before on things like your positive duty, your safety duties in this space, and there's a natural crossover with the use of these. So I think it's a really important topic that we're covering today. In essence, they are an agreement which includes a confidentiality clause and usually will include some kind of non-disparagement term. It can also include a bar to proceedings, and we'll look at that in a little bit. In terms of the difference between NDAs and settlement clauses in settlement agreements or agreements to settle or deeds of release, as some people might otherwise know them, technically we think that there is a distinction. Maybe if you want to explain what an NDA is as opposed to a settlement deed.
An NDA is more, it's a standalone document, it's a standalone agreement. There isn't that same exchange of things that might be going both ways that you might otherwise expect to see in a settlement agreement or a deed of release. Though, of course, for the contract nerds amongst us, you'll be aware and you'll be saying, but Kate, you don't need anything to pass between parties for there to be a deed. I know that, I'm aware of that. But that's more often where you see a deed of release or a settlement agreement being utilised. An NDA, I think what we're trying to describe to you is an agreement which is really just focused on not talking about what's happened, what's alleged to have happened. And as Tamsin said, potentially some non-disparagement clauses in there as well. So even in the not talking about the things, you need to be careful what you say about the people involved as well. So it's that real standalone agreement intended to stop certain types of behaviours, not necessarily that same exchange of money or a deal otherwise to sort out a dispute or a pending dispute.
And that might happen during someone's employment, or it could also, as you probably most people would know, a deed of release at either the exit point or after somebody has brought a claim, and you use the deed of release in order to kind of move on and do away with whatever proceedings they've brought. Now, although there is a distinction, when it comes to our good friends in the federal and state government, when they discuss this topic, when the regulators have discussed this topic, when it's come out of Respect at Work, to our mind, they've adopted a very loose definition of an NDA, and it really is something in the way that they describe it that also captures settlement deeds, deeds of release and those kind of arrangements. So whilst the traditional form of an NDA, as it kind of originally was conceptualised, might have had that really specific clause just dealing with one issue. The way we're going to discuss it today is really around every form that an NDA might take, including when it is a kind of a subset of a broader agreement that someone might have.
So really just talking about confidentiality provisions generally, but using the shorthand of an NDA.
Perfect. Now, how prevalent are NDAs in Australia? Hard to say. There's no official reporting. There are some reports that have been done by universities. We have some estimates from the Human Rights Commission that suggests that majority of matters that are resolved involving some form of financial compensation do actually also include a confidentiality clause. As you can imagine, there's got to be some kind of quid pro quo to what the purpose is for that financial settlement. In addition, as I mentioned, this report, the Let's Talk About Confidentiality report that comes out of the University of Sydney suggests that 75% of legal practitioners had said that they'd never settled a sexual harassment complaint without an NDA. Now, I think in a purely legalistic sense, if we were just talking about an NDA, maybe that figure's not that accurate. But when we think about the fact that we're probably entering into lots of deeds of settlement with people, a lot of agreements, post claims being made by employees, that 75% figure is probably quite low in actual fact.
I think, anecdotally, if you would talk to the practitioners in our firm, you would say it's probably higher up into the 90s would be my expectation, especially if there has been some type of proceeding or claim brought.
Absolutely. So they're pretty standard practice. I suppose the question is, when are you using them? How are you using them? And as we flagged at the start, we're going to touch upon, well, how can you do that in a manner that is aligned with best practice and aligned with some of the kind of ethical considerations that have come up in this space in recent times?
I don't mean to be sassy, but I am going to just pick up on something there quickly before we move on, Tamsin. And that is the bottom point there, which is around this idea of financial compensation. It would be, I think, our strong suggestion, although we're not giving legal advice in this context, that whenever there is any money passing between the parties or changing hands, it would be remiss or it would be ill-advised perhaps if you weren't accompanying that settlement amount with some kind of a level of assurance that that was the end of the matter and that all the parties would be able to move on from that point in time. So when the Human Rights Commission suggested it's a figure of 80%, I would again say it's probably closer to 90-something, if not almost entirely the case that, you wouldn't see any money passing hands without some kind of deed, settlement terms, NDA, whatever you want to call it. So, but as you said, Tamsin, it's really hard to have an accurate assessment of these things because that's the whole point. We don't know about them. So we're sort of grasping in the dark a little bit to work out how common they are.
Yeah, but at least from our experience, we'd say perhaps higher than 75, 80%.
Absolutely.
I would say almost every matter I've dealt with in this space has definitely had some kind of clause. Whether it had carve-outs, that's another question, but it's definitely had something in this area covered.
Perhaps we're part of the problem.
We'll find out.
We'll explore that.
So spotlight on NDAs, which is why we're here. Why have they received so much attention? They've received quite bad negative press. Fair to say that probably has all stemmed from Harvey Weinstein and a number of his cases involved NDAs, kind of like everything coming out of respective work. There has been that momentum for reform and momentum for change. Now, NDAs did come up in the respective work report. That's right, Kate?
That's right. So there was two kind of things that come out of the inquiry and then the report as well. The first one is, it was initially identified as an obstacle to people participating in the inquiry if they had entered into an NDA. So you can see how that plays out. Someone has had an experience whilst they were at work, perhaps made a complaint, perhaps not, perhaps had that investigated, but for whatever reason has ended up with some kind of document preventing them from speaking about that experience or their experiences generally. The Commissioner, Kate Jenkins, publicly came out and asked employers to allow for the partial waiver of those NDA provisions so that employees and former employees could participate and make confidential submissions to the National Inquiry. And I think that was quite successful and a lot of people were open to doing that kind of partial waiver.
Yes, for the specific purpose of the inquiry.
For that specific purpose. So you can see there immediately, okay, if we are preventing people from talking about their experiences on a policy level, are we potentially impacting the measures, the legislative responses that we could be putting in place to ensure these things aren't happening? maybe that's one of the reasons why we need to be a little bit more careful about their use. The other thing we need to note about the Respect at Work report was in relation to recommendation 38, which was that the Human Rights Commission developed guidelines outlining best practice principles for the use of NDAs, which was ultimately implemented, and we'll talk a little bit more about that later in the slide deck.
Yeah, we'll come back to that. NDAs in practice, we've touched upon the fact they've received some bad rap internationally. They've also received quite a bit of negative press in the Australian kind of media. We've put up some headlines, not to name and shame too many large corporates, but I'm probably sure it's probably relatively common knowledge or household knowledge that BHP and Rio are facing a class action at the moment in relation to alleged sexual harassment issues, particularly in I think in mining in WA. And there's been some allegations that those who have experienced that are not able to be part of the class action in some sense because a number of those people have signed NDAs, although I suppose, as we'll touch upon later, there's a bit of a question, well, have they already been monetarily compensated? But I know in that case, Rio has already given a waiver, at least to some of the women in that case, in order to be a part of the class. Not so sure about the others, but just an interesting kind of idea that particularly if you have had a bad egg, and I think these might be situations, particularly looking at the other example up there of Channel 9, I think that was about, is it Darren Wicks? I think that might have been the one where they were equally accused of using NDAs. I should say it was only an allegation of using NDAs to gag some of their female employees who might have alleged to have experienced sexual harassment at the hands of Mr. Wicks. This idea that they're not being used to give a complainant security that it's not going to be discussed or to give everyone an idea that this is all settled, but in actual fact to protect one person who might have engaged in multiple forms of bad behaviour across an organisation and to really hide the fact that that's what they've been doing.
Yeah, and I think that's a really important point to pick up. As you say, with respect to BHP and Rio, there's a suggestion and there's some additional commentary around the mining industry generally, that there are these pockets of systemic behaviour and that NDAs have been utilised to ensure that people who wanted to raise those complaints weren't able to raise them effectively, or to then excuse not really doing anything about the behaviour once the complaints were raised. And they're the sorts of mischiefs I think we're trying to negotiate our way through without chucking out the NDAs. That's right, yeah.
So what is the legal landscape or the changing legal landscape when it comes to NDAs? Well, we have seen quite a bit of reform internationally in this space. I think the first country being Ireland, not that it was the first to move, but it's, I think, the poster child that now some of our Australian states are looking to. They passed a law which prohibits the use of NDAs between employers and employees in cases of discrimination, harassment and victimisation, unless certain exceptions are met. Some of those exceptions include where the employee has raised the desire to enter the NDA, not the employer, where the employee has had access to their own independent legal advice, but it must have been paid for by the employer.
That's an interesting thing. We'll come back to that one.
A very interesting condition there. Or if it has been entered into by virtue of one of their kind of court tribunal proceedings, similar to kind of a commission proceeding. If it's a part of that, then it also, my understanding is it's subject to an exemption. There's some other slight nuances, but as you can see, some pretty what would be considered in the Australian market, I think, quite extreme exemptions in order to otherwise be able to use an NDA in Ireland. In Prince Edward Island, another form of island in Canada, I believe a province there, they've had a similar model to the Irish model, but they've actually applied it broader than just the workplace. So they've applied it to forms of harassment and discrimination in a general sense. In the US, and I'm sure most people can read between the lines as to where this one might have come from, but in December 2022, they passed what was called the Speak Out Act in their Congress, which prohibits the enforcement of pre-dispute NDAs or non-disparagement clauses regarding allegations of sexual harassment or assault. So basically that's saying you can't use an NDA or have a non-disparagement agreement or clause in an agreement until someone has actually brought a proceeding or a dispute with another party.
So that would be if I bring a complaint at a workplace level, we perhaps reach some kind of agreed resolution to that. I exit my employment or someone exits their employment. There's no NDA permissible in that circumstance.
No.
But if I then go off to a court or tribunal and make a complaint.
At that point, we could trigger the negotiations before we ended up before the court. Yeah, absolutely. And last but not least, the United Kingdom. Now, the United Kingdom, almost at a similar time that we had the Respect at Work report, also had a House of Commons inquiry into the use of NDAs, which had some interesting findings, I must say, in terms of the benefits to the victim or the person who's come forward with the complaint or disclosure. But they've decided to go forward and only prohibit the use of NDAs in the higher education space between staff members, students, and interestingly, visiting speakers. I'm not sure the context of that, but I'm sure there must be a story behind it. And I think that's perhaps a good lead into something you mentioned about the mining industry. We are seeing reforms, as you can see, that are really targeted at particular issues and areas or pressure points where there have been perhaps a sense that they haven't been used appropriately, rather than seeing that broad brush approach to banning them entirely everywhere in every single place.
So one of the things I just will come back to just quickly before we move on, Tamsin, was you mentioned in relation to the Irish reforms that there was a carve out for where there was proceedings or where the terms were entered into as a result of resolution of proceedings.
Yeah, that's my understanding. Yeah.
So people, our audience might be familiar with the fact that if you go off to the Fair Work Commission, for example,
yes,
they will offer you their own terms of settlement, which do contain confidentiality provisions. Do you have any thoughts around, in Australia, are we going to see sort of those types of mechanisms changing as part of these broader reforms, or do you think that that's a sort of sensible recognition that there might be a time and a place?
It's a really good question. And I think in a second we're going to turn to my home state of Victoria, who are leading the charge as always in these spaces where they're going out on a limb and reforming first. And I think it's going to be really hard to not provide an exemption in the commission space, particularly when it's seen as a friendly place, a place of resolution, a place where an applicant does have perhaps a lot more fairness than they would have in that normal perception that there's an imbalanced relationship between an employer and employee. I think there's a real sense that the commission does a very good job at making sure applicants are given a fair go, that everything is explained to them, and that the terms are not written in an overly complex legal manner. If anyone's seen not that we advise using it, but the Fair Work Commission terms of settlement, they are incredibly brief. And incredibly simple to read and understand. And
I think that's, again, one of the other things that we'll touch on later on in the materials, which is the importance of making sure that when we are going to use, we've made a conscious decision that an NDA or a confidentiality provision is appropriate, it's drafted in such a way that it is usable, understandable, and actually accessible by an applicant, especially if they are not necessarily legally represented.
Great point. Which nicely leads to my home state of Victoria.
I'm going to leave this one to you.
Victoria, always pushing the limits. I think we were having a discussion earlier this morning about all of the ways that Victoria has reformed first and has, I suppose, infected the rest of the country with our ideas about...
It's an interesting choice of word, infected.
Yes, things like wage theft and the like have all started in Victoria.
And the positive duty, of course.
The positive duty started there, and labour hire licensing, the list goes on, but another space where we might be leading the charge, not yet in law, so don't get too stressed if you're operating in Victoria, but there definitely is a push on in Victoria to potentially legislate to either put some restrictions around the use of NDAs. I would say the sense is perhaps they're not going to completely outlaw them, but I definitely get a sense that they're going to look at some reforms that place some caveats or restrictions around their use or put some requirements on the way they're used. How this has come about, they had a ministerial task force. I put up some of the findings on the slide around the fact that this task force apparently found that NDAs are being misused to silence victims, protect employer reputations, and hide serial offending and offenders. I would say it wasn't a hugely, public inquiry where there was, public testimony and evidence. Being by very nature NDAs, I assume that's not quite possible, but, just take their findings with a grain of salt. I think they are a bit,
potentially a little bit influenced by the questions that were being asked.
Yes, and the desire, I think, to have the outcome that they are leading towards. It recommended that task force that Victoria did reform and reform pointing the direction of the Irish model, or perhaps pick up some other things from the UK and the US. They then invited submissions on some particular questions around reform. We put up a bit of a sample size at the side on some of the issues they discussed, like mandatory information and education, requirements requiring independent legal advice, or prohibiting unless requested by the complainant, picking up on that kind of Irish model where it has to be brought forward by the complainant. And they've looked at whether or not these proposals have received opposition or support. The government has said they're going to legislate this year. We don't know exactly what that looks like. They haven't even indicated which particular measure they might go down, but I think it's definitely a watch this space, because I would suspect we will definitely see what it looks like. We don't know, but we will definitely see some form of restriction in Victoria on the use of NDAs in some shape or form.
And then, as you said, likely to roll out more broadly, given the pioneering status of Victoria in relation to other legal considerations in this space.
Yeah, exactly. So I'd hazard a guess we'll then see other similar states, maybe our good friends in WA might take the charge next, or other friendly states, maybe even New South Wales. Who knows? Watch this space. But definitely this is in part, I think, the reason why we're going to have a discussion about what is best practice, what does that look like. Perhaps it's not exactly what Victoria is proposing, but there's definitely things you can do to make the NDA process be as fair to all parties and make sure everyone understands exactly what they're entering into before they do sign.
Yeah. Okay.
Even if people do get buyer's remorse later. All right. AHR NDA guidelines.
Well, and I think it's really important to say, so we've just spent a little bit of time going through legislative reform in other jurisdictions and then also flagging that pending legislative reform in Victoria. So it is important to say at this stage, essentially there's no limitation on whatever you want to do, go for your life. Is that an appropriate response having regard to all of the sources of legal obligation in this space? I would say probably not, because, and this is one of the things that we're going to pick up later on in the content and some of the questions that have been coming through. How do we marry up, or how do we reconcile our obligations under the positive duty legislation, so the Sex Discrimination Act, and our work health safety obligations with the continued use of NDAs? And really that's the multi-million-dollar question.
Correct.
In the current state we're in, which is you can still use them, it's all fine, is that then potentially giving us cause for concern with respect to our other legal obligations? So the Human Rights Commission has done a lot of work in this space. As you would know if you've been exploring your positive duty compliance options, there is a lot of guidance material that has been published by the Human Rights Commission to try and give employers a bit of an idea around what they need to be doing to discharge that particular obligation. As we know, a lot of the recommendations of the Respect at Work have been implemented. A lot of the guidance material does still focus around the Respect at Work report and the inquiry. So we do have the guidelines that the Human Rights Commission has come out with. And I think, relatively speaking, they're pretty sensible, fairly, not too radical, but we'll go through them quickly now because this gives some context to some of the other recommendations we'll make later on in the content. The first one is consider the need for a confidentiality clause on a case-by-case basis. And I think this is a really important thing, a bit of a stop and prop opportunity.
Absolutely.
So just because you have a particular approach internally to the resolution of disputes, which might involve a deed of release, terms of settlement, an NDA, doesn't necessarily mean that should or is going to be the appropriate way of resolving particularly sexual harassment disputes and other related unlawful behaviours. So is it actually appropriate in this case for us to implement an NDA or propose that the parties enter into an NDA? And I'll just pause briefly here to say, when we talk about this, we're not just talking about in relation to a complainant. We might also be talking about a respondent.
Yep, absolutely.
Or both, in fact. So there might be circumstances in which we get everyone involved in a particular complaint to enter into an NDA. What happens then, though, is that can sometimes make us hamstrung in terms of what we can do in response to a complaint or an investigation if there has been one. So, for example, if we're thinking about our positive duty obligations and our obligation to eliminate certain types of behaviour, as well as our work health safety obligation, are we actually going to be able to do that if we're not able to utilise some of the information or some of the findings or the learnings that have arisen in relation to a complaint because we've tied those things up really tightly with an NDA? I think there's a real question about that. So it might be the case that you say, well, is it appropriate here? Maybe it is still because perhaps the victim or the complainant wants that level of protection, but can we still utilise that information, use it in an appropriate way to ensure that we're discharging our obligations elsewhere?
And is there actually a trade-off? I think occasionally we see people, just as standard practice when an employee leaves, having this desire for people to sign a deed of release,
Absolutely.
even though they're just getting their lawful entitlements under the Fair Work Act. You might have someone who, for example, has made a complaint about sexual harassment and decides to leave the workplace, in whatever form that might be. But that might not mean that you're even making any monetary payment to them. You might, in the circumstances, say we're going to investigate, they choose they don't want that to happen, they just want to go. Maybe really question whether you actually need to have them sign a deed of release in that circumstance.
Absolutely. Yeah.
Don't just have it as a standard practice, I think is kind of the message we're trying to send.
The second part of that is when you make that decision on a conscious level that you do think an NDA or a confidentiality provision is appropriate, make sure the scope and duration are commensurate with the level of severity and the level of sensitivity of the things that we're talking about. So we'll talk about duration in a moment, because that's one of the questions we quite often have with respect to confidentiality provisions. But perhaps you want to think about the scope of the provision that you're asking someone to enter into. So there's really practical things like, are we asking this person to enter into a document which is so strict, which essentially means they can't talk about what's happened with their immediate family or seek some psychological support? Or are we making it, quite a pragmatic approach to say, well, we just really don't want you talking about this in the media or the public sphere or with your ex-colleagues? So really think about that scope and making sure that that's an appropriately limited sphere over which you're trying to control that person's behaviour. Duration is also a really important one. So it's quite possible to have an NDA that is of indefinite duration.
Yes.
Is that actually appropriate in the circumstances, or should there be a time limit so that that person ultimately is able to disclose what happened to them or what they say happened to them? The third point there, I think, sort of ties into what we were talking about when making those decisions around what your approach is going to be generally. So is the NDA or the provision going to prevent us from responding to systemic issues and providing a safer workplace? And the way I kind of see this playing out is, for example, if you identify the need to undertake a risk assessment process arising out of a complaint, because perhaps that complaint has identified some hazards about which you weren't already aware or knew, or different hazards or different risk profiles arising from those hazards, are you going to be able to actually see that risk assessment process through to completion, identification of control measures, implementation, review, and all of the things that the Human Rights Commission will expect to see to ensure that you've discharged your positive duty if you have entered into an NDA, which means that we can't talk about specific details of a particular case?
So Mariah, saying with these first three, it's not we're saying don't use them, but we're saying it's all about nuance in the terms you use.
Right.
Whilst templates are great as a starting point, make sure you're adapting that to your current circumstances.
That's right. Yeah. And I think that's where we're sort of saying our view, and we might be wrong, sometimes we're wrong, is that probably in Australia we won't end up with a situation where NDAs are outlawed entirely.
Hopefully not.
More likely that we'll see some limitations, and that's reflected in the Human Rights Commission guidelines. As you can see, and as Tams has just pointed out, we're not going toward an outcome where they're saying you can't use them, you shouldn't be entitled to rely upon them. It's just about making sure that they're appropriate for the circumstances. And that's, as we said before, making sure that they're clear, fair in plain English, and where necessary, translated or interpreted. And this is something that I will just pick up really briefly here. What we need to be conscious of, and again, if we've done all of our positive duty mapping exercises in terms of our particular hazards in our workplace, we might be aware and we might be conscious of the fact that there are individuals or groups within our workplace who have a high likelihood of being exposed to or experiencing sexual harassment in the workplace. So, for example, we might have a high proportion of migrant workers in our workplace for whom English is not their first language. That cohort is more likely to experience sexual harassment. That's just what the stats show. So if we've got that consideration, we have a complaint brought to us by a member of that group, is it appropriate that we put quite a complex legal document in very technical English across the table to that person and expect them to be able to understand what it is that they're agreeing to? And I think the answer to that is no. So what do we do? Do we need to consider having that document translated? Do we need to think about independent legal advice and support, which is point number 5 here? What's your view, Tamsin, on this idea that we should just say, here's the document, off you go and get some legal advice, come back to us when you're ready to sign?
It's ambitious. It's very ambitious, particularly when we're dealing with, I must say, those who are in the higher risk categories of people who report that they experience sexual harassment. They're usually younger, migrant workers, or people who might have another protected attribute, people, for example, with a disability. We know that their ability to access those support services is probably not going to be as high as we'd expect from, our senior managers and our exec and their ability. So yes. I think just having that clause saying we've told you can seek legal advice and you've understood that and have chosen not to, it just doesn't cut the mustard anymore in terms of fairness between the parties. And it could be that you direct the person to various social kind of type legal services where they might be able to get some assistance and they choose not to utilise it. But I think simply saying go find your own lawyer, good luck, perhaps isn't meeting what the regulators are hoping people do in terms of using NDAs in a fair manner.
One of the things I've seen just anecdotally of recent times is applicants or employees who were asking to enter into a deed of release or settlement terms asking for some additional compensation so they can obtain legal advice as part of the settlement outcome. So that can be a way that you might consider that. There's some beneficial implications for tax treatment of payments. Yes. So there's a range of reasons these things can work for everyone. But I think the bottom line, as you say, Tamsin, is it's not going to be good enough if you just say, off you go.
For most people, I must say. Right. If you're dealing with senior level people, probably very different. Or it's lawyers. Ourselves, we probably don't need to go and get our own legal advice, but you never know.
Or someone who's represented by a union.
Yeah, or someone's got exactly. Probably a very good one. If someone who's represented by a union is in a very different position to somebody who's unrepresented entirely. Yeah.
So finally, we also just need to have regard to, if we think about our general Human Rights Commission expectations around positive duty, making sure that we're discharging our obligations, a lot of the focus there is on the welfare and the rights and entitlements, the views of the person making the complaint. So one of the expectations is that when we're negotiating, when we're having these discussions around what are we going to ask you to sign, if anything, that the well-being and safety of that person is paramount, and that those discussions, in addition to any of the investigation or complaints handling that we've already done, are trauma-informed, culturally sensitive and intersectional. So as we said before, intersectional in the sense that we're recognising whether that person has a disability, whether that person's from a non-English speaking background, and those other things which might have bearing on their participation and their experience of that process. So we're applying the same principles. I think we would say that we've hopefully got in place to deal with sexual harassment complaints generally to resolving matters, whether it's subject to an NDA or otherwise.
Nice. Now, it's probably important to say also these are guidelines. They're not mandatory. They're not required. They're simply, I suppose, the AHRC's form of best practice, but definitely not required. And I should also flag, again, being from Victoria, we have our own guidelines coming out of VERIOC, our equivalent AHRC, and it's got some small nuances, I must say, a few different guidelines there that people should pick up on. But I would just suggest bearing them in mind and taking on board those that you might be able to put into place. But it's in no means a sign that you can't enter into one because you didn't have it translated, for example, particularly in circumstances where you might think someone's got sufficient level of English, even if English isn't their first language, just by way of example. But should we keep moving?
Let's keep moving.
NDA best practice. Oh, we've flipped through that, but sorry everyone for motion sickness. Ethical considerations.
Right. So what we're going to talk about now is, so we've established that there's no bar essentially at the moment to entering into an NDA, and there might be some real good and cogent reasons why an employer wants to enter into an NDA. So there's a question here that I'm just going to ask or pose to you now, Tamsin, because I think it's relevant. So the questioner wants to understand, maybe it's obvious, but what do you think employers are actually protecting by an NDA? So is it reputation? Is it admission of liability? Is it precedent-setting rate amount of payouts? So what do you think the purpose of an NDA is?
All of the above, I would say. I think reputation is where the initial thought goes, but I think the barter proceedings part that often comes, and this idea that this matter is resolved, we're not going to have this in the public domain, we're not setting a precedent for anybody else, all of those things can be seen as beneficial. It's just going to depend on the circumstances. But I think the main one is not just perhaps reputational damage in a public sense, but also internally what that can do to an organisation.
Yeah. So I think, so that's the benefit for the employer, obviously. think the really important thing, and the thing that we had a discussion about before we came together here today and in preparing these materials, is our experience, and it's anecdotal, that it's often the complainant who will request some degree of assurance that what they're about to disclose or the information they disclose in the course of a complaint handling process or investigation is going to be kept confidential.
And so many times people come forward to us and say, someone's made a complaint. They don't want us to tell anyone else. They want it to remain confidential. And in those circumstances, everyone's like, well, how do I deal with this and deal with my positive duty? How do I handle this? And NDAs play, I think, a really important part in giving that person the confidence that it's not going to go and be told to everyone. And maybe in some circumstances, they don't even want it investigated because that in itself poses a risk in terms of it getting out to others.
So I think there's benefits to the employer, evidently, but there's also potential significant benefits to a complainant. And it would be inconsistent with our positive duty obligations if we were to gloss over that aspect of things too much.
Yeah. So particularly in a lot of circumstances that we haven't even substantiated the allegations and we might be entering into an NDA. Obviously, if you're entering into it at the end point or after somebody's made a claim and as a part of a broader deed of settlement, that's very different. But if you're entering into one while someone's still employed, typically we may not even substantiate or do a full investigation into that. But we are resolving it and we may be paying some compensation as a part of that.
Yeah. So that's all the good stuff. There's obviously some bad stuff.
It's got a bad rap. We've given some headlines. We've shown you where it perhaps goes off course.
And I think part of that is because they can be sometimes used to cover up systemic or, repeat offenders, basically.
And I think that could be unintentional. I think sometimes there's this sense that, we endeavoured to protect this person and entered into all these NDAs. It could simply be that there was no ability to track where we were entering into NDAs, who was entering into them. Teams and HR personnel can change. And if we've not got a method of tracking that, it could be very possible that unwittingly we've ended up entering into multiple NDAs all as a part of the one individual's behaviour across multiple employees.
Absolutely. And if we, again, think about what the Human Rights Commission says about discharging our positive duty, is making sure that information and reporting is consistent, systematised across an organisation. If we're prevented in doing that properly by entering into NDAs at particular parts of a business, especially when we're talking about a large business, you can immediately see the problem there in terms of our positive duty compliance. The other thing I would say on that regard as well is, if we're entering into, especially with our large organisations as well, NDAs perhaps at that middle management level, is that information getting to the board? Who's actually able to sign off on an NDA or authorise the employer to enter into one? I think that's a really important consideration to ensure that there is that level of familiarity or oversight over why are we doing it? When are we doing it? What else do we need to do? Has it uncovered a problem that's more broad in this particular circumstance that it's intended to cover?
I must say this is probably harping back to one of our former slides, but this is one issue that Channel 9 had when it had its big issues with the said individual. And the CEO came out and said, I never signed an NDA. I've never entered into one. And I was like, well, when would the CEO be signing an NDA? And this was the criticism of the broader media and saying, well, who is signing these documents? Who does know about them? And I think then if you are going to be entering into them, one of the ethical considerations is, well, how can we make sure we are keeping stuff confidential, but we're also being consistent and we are making sure that those who need to know actually do have the knowledge that they need to know about what happened in these instances and what learnings can be taken from them for the broader safety of everyone else in the workplace.
Absolutely. I think the final consideration there as well is that if people feel like these issues aren't discussed, they're kept confidential, they're swept under the rug, there can be a lack of faith and confidence in the processes that are followed. So if people don't know that things are going to be investigated or dealt with appropriately, they can't have that level of comfort or confidence in an employer to actually come forward and make that complaint. So are we potentially reinforcing behaviours? Are we potentially making it appear that things aren't going on when in fact they are? Simply because we're not talking about them. So, there are a range of potentially negative consequences or negative implications for entering into an NDA. What our challenge is, of course, is to balance all of these competing interests.
So, best practice. Should we just outlaw NDAs, not have them?
Absolutely not. Let's not do ourselves out of a job, Tamsin. No, I don't think so. I don't think that solves the problem.
No, I don't. And I think all of these reports and government reforms and people who talk about it really do perhaps ignore that point that you brought up earlier about the fact that a lot of the time it is the employee saying, I don't want other people to find out about this. I want this to remain confidential, or I don't want this to be fully investigated, but we want to seek a resolution for them and have it resolved, but address it in a manner that, keeps everybody happy, or everyone's in part, I don't know, win is probably the wrong word, but everyone has a
sense of finality.
A sense of finality, exactly. And NDAs really do, when used appropriately, serve that purpose for both sides, or frankly multiple sides if there are multiple parties to this NDA. So some important considerations.
The purpose of the NDA. So I think this comes back to a real consideration of, do we just have this blanket approach that everyone on their way out the door enters into terms or a deed or an NDA? I think that that's probably not the best practice approach. That's not what we're suggesting you do. So let's have a think about why we're using it. Is it, as Tamsin just said, because the complainant has indicated to you that perhaps they might be hesitant to engage in a formal process if they don't have that level of protection? Or is it to protect the very successful but problematic employee who you want to keep in the organisation and not actually do anything to resolve their problematic behaviours? If it's the latter, problematic, potentially.
Ensuring voluntary participation and informed consent is an interesting one, because obviously some of the jurisdictions we've spoken about have said, well, it can only happen when the employee brings forward the idea. Now, the fact that they think that employees just have this magical idea of an NDA in their head, I think is also a bit far-fetched. But I think it's fair to say making sure somebody, wants to participate, that they understand the purpose, that they understand the intention is not necessarily to silence them, but it's to give everyone the sense of finality, as you well spoke about, and that might involve some other agreements, and making sure that they have that informed consent can mean perhaps either yourselves require a greater level of educative space that you need to provide for the employee, or it's that external assistance or legal advice that they might require as a part of the process.
Yeah. A cooling off period, and that's an interesting one, I think.
It is. Some of the jurisdictions have spoken about it in terms of a reform. None of them has expressly put it in, but I think it's an interesting to think about, and it might provide that window opportunity for somebody to go and have that extra conversation with someone. And I don't think it needs to be a long time. It could be 24, 48 hours at most, but I think that also gives then that greater sense that they have entered into it willingly. And we use them for buying houses. Why wouldn't we use them for the NDA process? I think it's a great idea.
We've had a question come through that I think it's probably a good time to talk about now. So what about NDAs to prevent future action or claims, but not to gag people? So, for example, they can talk about their experience at work, but not take any action about it. What do you think about that?
There is nothing stopping you from doing that. And I do, honestly, I had a conversation with another colleague this morning, wonder if that's the direction we head, particularly if you're dealing with more cultural problems or something that's not dealing with, one particular person who you may not want to disclose, or maybe where the sexual harassment isn't something that people are reputationally that worried about coming out. I think the stigma around sexual harassment in the workplace, now that we have a positive duty that more people are reporting, is kind of going away, both from those who are making complaints, but also from employers, and saying, we want to know about these problems. We want them to be out there in the open so that we can address them. That obviously comes with its own level of risk. But I think that bar to proceedings point, which isn't, necessarily in the title of an NDA, but is in a part of lots of deeds of settlement. I personally think if you're giving compensation to someone, you don't want them coming back and making a future claim.
Yeah, and so I want that level of protection.
Absolutely. And so I don't think there's any problem with doing that if that is the right outcome for your business and your organisation. I think it's going to be that case-by-case scenario. Sure. And in some situations, I think that might actually be the perfect balance to end with.
Yeah. And what about other sources of confidentiality obligations in other documents? So, for example, a contract of employment. Do you think that's going to do the job that we want it to do if that confidentiality piece is really part of the key aspect that we're trying to achieve?
Right, because you're talking about the confidentiality clause might be in someone's standard employment contract.
Yeah, that's right. Yeah.
That's not going to protect you in circumstances where somebody might experience sexual harassment at work. They're fully entitled to discuss that, assuming it's not covered by some kind of commercially sensitive information, which is usually where that confidentiality clause relates to. That's probably not going to be applicable. I can't really think of many that we've ever drafted that would have applicability, unless you'd assumed somebody would experience that in the workplace before you signed their employment.
Hopefully you don't.
Yeah, exactly. So I would say as a general rule, in almost all circumstances, that's not going to give you the protection you require. You require a separate confidentiality clause or NDA or deed of release in order to give yourself that confidentiality protection that you're looking for.
One final question, and then I'm going to talk about without prejudice discussions because I think that's really important. What about standard confidentiality requirements or reminders in letters to complainants? So we talked about confidentiality provisions in contracts of employment. What about when a complaint is made and then we send a letter to a complainant or a participant in an investigation and say, you've required to keep all of this confidential? Is that going to get us there?
Well, that would usually be part of the lawful and reasonable direction that we give someone as a part of an investigation process, but I would really question the reasonableness about that in a longer term sense as to whether or not you would legally be legally able to enforce stopping an employee from discussing something in perpetuity where they've experienced in the workplace. For the purpose of the investigation, I think we are on solid ground for that purpose, but beyond that, I'm not sure if you have a different view. But
I think that's right, because it might be something where, or it should be something indeed that forms part of your general process so that people can participate in a complaints handling or investigation in a free and, full way and not feel like that information is going to make its way to the broader workforce. Should you, in some circumstances, sign an NDA while those processes are ongoing? Maybe, depending on the sensitivity of the information. You might form a view that those standard lawful and reasonable directions are not going to be enough to give you the level of protection you think the process requires. No problem, I don't think, with those sort of standard reminders or standard directions. No. They're not going to offend any of the provisions that we're potentially talking about, limiting your ability to access an NDA as a standalone document, but just a consideration of, is that enough for our particular circumstances?
Yeah, exactly.
So before we move on without prejudice conversations,
how do they fit in?
How do they fit in? I think there is a increasing preparedness. I don't know if it's increasing or whether it's just, perhaps my experience in the last little while, for employers to jump to having a without prejudice conversation whenever anything happens as a way of quickly resolving a matter, perhaps without the need to investigate, which...
Are they actually without prejudice though?
This is the problem, Tams, and this is the problem. In a lot of circumstances, they're not. And just because we call it a without prejudice conversation doesn't mean that it is a without prejudice.
So we can't just give it the label and then it gets the protection.
That's right. Okay. So if you're thinking about, this is all getting a bit much and I'm not sure how to handle this and I really think there's the scope to perhaps come to some kind of resolution here, I'd really be encouraging you to get some advice before you go down that path. Otherwise, you're potentially putting yourself in a situation where everything you say during the course of that conversation can be relied upon by that person.
Yeah, it does require certain things in order to get that protection. So, yes, I think great advice. Seek some advice.
Seek some advice.
Before you try and give it that label. Now, should we go to the last point, not forgetting about our legal obligations?
That's right. Yeah, because I think that's a good segue into the next couple of slides. So, as we've said already, there is a complex sort of matrix here that we're talking about of intersection with our positive duty, particularly, which falls into the Sex Discrimination Act. And as you know, there is a webinar that we have done previously. If you're interested in understanding more about your obligations, it is available for some light review, and your work health safety obligations as well. So if we think about it from that perspective, just because we enter into an NDA doesn't mean those obligations fall away. No. So what we need to be conscious of is the fact that those things still exist, and how are we going to marry up our expectations or our obligations under those sources of legal obligation with what we might want to do pursuant to an NDA or settlement agreement to resolve things neatly over here.
And it's fair to say, I'm not to criticise them too much, but I don't think our regulators and our laws have quite conceptualised how these things can work in sync. I think there's this stigmatisation of NDAs to say that they're bad, we don't want them, when in reality, as we've discussed often, in our experience, they are almost complainant-led in that they have a desire for it. And so how do you marry their desire, as many people bring to our attention, I'd like to keep this confidential, how do you marry that with your positive duty? How do you marry that with your safety duty when it's not just good enough to say, they didn't want me to tell people, so I don't have anything else to do, wash my hands here?
That's right. So I think the bottom line, as is always the case when we're talking about positive duty or work health safety, is doing nothing is not an option.
No.
Even if you do enter into an NDA, hopefully you've had that drafted or you've got that crafted in a way that it doesn't prevent you from taking appropriate action to discharge those other obligations. But the reality is, just because we think no one's going to know or no one's going to find out about a particular complaint or a situation doesn't mean that we should rely upon that as protection. As we know, the Human Rights Commission has its own enforcement jurisdiction. The safety regulators are really onto sexual harassment as a psychosocial hazard and employers' obligations in that space. So the fact is, and you're going to talk about a case in a moment about the public interest and NDAs, that even if you do have an NDA in place, you still need to do something about the behaviour or the conduct or the complaint that ultimately led you to that place.
What should we be thinking about then when we're entering an NDA with a mindset to, okay, I've also got to meet my positive duty, I've also got to meet my safety duties? How does that change the way we might think about NDAs when we're deciding to enter into them?
So it might be about the things that we've spoken about already. So, for example, the scope. So do we have carve-outs perhaps for certain things? So might it be appropriate for us to be able to discuss the circumstances of a particular matter with a group of people within the business? So we don't just have a blanket prohibition on discussion of the matter, outside of the people that already know about it. So you might need to bring your safety colleagues into that discussion. So we have an NDA which is clearly drafted such that we're not offending the provisions of the NDA to do that. And generally speaking, there will be a less onerous obligation on an employer in the sense that confidentiality provisions are usually drafted such that you can discuss things for genuine operational reasons. But when we're talking about sensitive matters like this, let's make sure that the drafting isn't so strict that we can't have those discussions.
Yeah.
I think that's an immediate suggestion I would make. The other thing to do, I think, in this space and to consider as well is how can we actually use the NDA to discharge some of those obligations. So if we're thinking about having to demonstrate that we've utilised a victim-centred approach to managing complaints and responding to behaviours, if a victim comes to us and says, I want to tell you about what's happened to me, but I don't want you to investigate, that's always going to put us in a very difficult position.
Tricky.
So if we were to say, well, sorry, too bad, too sad, I'm going to need to investigate anyway, which can sometimes be the temptation and indeed sometimes might be the appropriate thing to do, can we use an NDA to give that person a level of assurance that, yes, we are going to proceed with an investigation which may be against your initial wishes, but here's the things that we're going to do to make sure that you're fully supported throughout that process. So it can also be a tool, not necessarily a barrier.
And I must say I've seen some settlement agreements that have been entered into that actually require employers to take steps that would help them meet their positive duty obligations, things like additional education and training for certain individuals. Having that in the NDA can actually also kind of help you then take the steps you need to take and ensure that you're doing them inside the confines of the NDA because you've got the authorisation of the person who's being party to the behaviour to agree to do that. So that can be helpful as well. Shall we keep moving? Because there is a little bit of a touchy subject when it comes to NDA enforcement.
Go for it.
How effective are NDAs when it actually comes to the crunch and somebody decides maybe they do wish to disclose something?
Well, I'm going to give the classic lawyer response, Damson. It depends. The problem is, and this is a discussion that we always have to have around deeds of release and the various other mechanisms we might use to resolve a dispute on a final basis, is that a large part of the effectiveness of those documents is the disincentive to the person to do the thing that it says that they're not meant to do. Because in terms of enforcement, your real options are to go off to a court and seek either an injunction, so an order saying a person needs to stop doing certain things, or damages if you can demonstrate that you have suffered some kind of loss as a result. So ultimately, if someone contravenes an NDA or some other confidentiality provision or indeed another term of a settlement agreement, you're still going to have to go off to court to try and enforce that. And that's even where there's been no money passing between the parties. So if there's been money, I think there's a perception that we'll be able to just immediately try and claw back or recover that money.
Yep, send them an invoice, please.
That's right. Please pay that back because you've breached your deed. No, unfortunately, you're still going to have to go down the path of suing that person to get any kind of relief.
Now, you've put an interesting point on the next dot point on defamation. How does this fit into how people enforce deeds?
I mean, the defamation piece is a really interesting consideration in this space, because I think people look at NDAs as a bit of a protective mechanism against a person coming forward, perhaps using the media, perhaps using social media at a more micro level. We do, if we don't have appropriate safeguards in place, open up that risk of defamation litigation with the associated complexities or interesting challenges faced by the truth defence, which, you know, the Bruce Lerman experience would perhaps give pause for people bringing defamation claims in relation to sexual harassment matters.
Yes.
Less said about that, probably the better. So we do have to be conscious of that. And I think the final thing that we'll just touch on before we move on is we did briefly mention this earlier, Tamsin, around how long can you rely upon an NDA? I suppose the answer is, how long does the NDA say you can rely upon it for?
Exactly. And what happens if it's silent? Is the assumption then it just continues in perpetuity?
That would be my argument. You know, perhaps if it was appropriate, there should have been some consideration given by the parties to a particular period. And that might be one of those areas where we see specific direction given for enforceability. But at this point in time.
But give some thought to it, I think, is the message.
That's right.
And if you want it to be indefinite, make that very clear in the NDA. Don't just leave it to chance and leave it to interpretation. If you think, a shorter period would be more appropriate, then put that in. But, bear in mind your circumstances may change. All right, we've got two very quick cases we thought we would just touch upon, because they kind of intersect with the enforceability of things like confidentiality clauses and NDAs or settlement agreements. The first is High Court authority. Now, this is a bit of a strange case. It actually was a case involving the police and our good friends at ASIC. It turns out there were some employees at ASIC that were involved in some kind of training exercise. We don't actually know, but that may have involved some unlawful conduct, and the police wanted to investigate what had gone on in this training exercise, and the employees of ASIC said, sorry, can't talk about it. Can't talk about it. We signed confidentiality agreements with our employer ASIC, so unfortunately we can't tell you what happened in this training exercise. This goes up the whole way to the High Court, and the High Court says, nice try. Confidentiality clauses in NDAs can't be enforced if they attempt to prevent reporting to police, regulators and the courts, or where they otherwise are deemed to interfere with public interest. And I think that's quite interesting in terms of sexual harassment, particularly if you have some, prolific issues with a, particular person who might have been highly problematic. If you're sitting there thinking, great, I've got all these NDAs that might protect me, and that person is particularly engaged in criminal type sexual harassing behaviour, that might not actually give you the protection that you think it will be giving you. And I think to that end, it's perhaps just a good reminder of, if you are entering into NDAs that do involve behaviour that might be criminal or quite serious, a good reminder for anyone operating the ACT that you actually have a safety duty to report that to the regulator if it meets that threshold of sexual assault. But for everybody else, it might be worth having that discussion about, okay, do we also need to report this to the police, even if we are entering into an NDA, or do we need to put in a carve-out that expressly makes clear that somebody, if they wish to report something to the police, are entitled to do so? The next case is a interesting one. This one actually, talking of Bruce Lerman, takes us back to Parliament. This involved a woman who was employed by former One Nation Senator Brian Burston. She had her employment ended with Senator Burston, and she'd subsequently made an unfair dismissal claim. And as a part of a Fair Work Commission proceeding, she signed a deed of release which included that mutual release for all future claims. The standard term we all probably would see. However, she subsequently, almost a year later, decided to bring a complaint in the Human Rights Commission for sexual harassment, sex discrimination and victimisation. You're probably sitting there thinking, well, how did she do that? She's got a bar to proceedings, right? I thought we drafted that in. Well, in seeking to be heard by the federal court in this instance, because it didn't resolve at the Human Rights Commission level, she tried to go off to the federal court. She said, well, I want to apply a principle of equity, and there's a principle in equity that says that a party cannot rely upon a certain legal right that they're claiming if their reliance on that is unconscionable. And she'd said that in this case, the Commonwealth Government, being her employer, former employer, was attempting to do that by attempting to preclude her from bringing this claim because of the way that they had acted, or according to her, had acted in the conciliation. She'd said that they had actually suggested to her in the conciliation that it was only about the unfair dismissal, that she would still be able to agitate a sexual harassment claim, because I feel like that must have been a part of the kind of discussions or reasons for her termination, and that she would also be able to bring a workers' comp claim. And she said that these representations were never corrected by any of the members of the department from the Commonwealth who had attended the conciliation. Now, this went before our Justice Lee, for anyone who, again, might remember him of the
fame.
Yes,
yep.
And he has a wonderful way of putting things, so I have put up just a little bit of a quote from him, and he said, "The real question for me in the present circumstance is whether the misapprehension, A, were known to be held by Miss Leach by representatives of the Commonwealth, and or B, became about by reason of some action or conduct of the Commonwealth which renders the deed being enforced according to its terms by the Commonwealth as being contrary to conscience." So, in essence, he's saying if they were on notice that she had a misunderstanding and they didn't take proactive steps to clarify that, or they misrepresented what the terms of the deed were to her, then he might be willing to overlook the deed and basically say that it's unenforceable and that she could bring her claim. However, he did find in this instance that the Commonwealth had done a great job of keeping very diligent records, contemporaneous notes about what had happened in that negotiation, and he had a greater belief in what the Commonwealth said, which is what they'd said is that it was made very clear in the conciliation what the terms were, that she couldn't bring any other proceedings, and that was on the basis for which she was paid a settlement payout, and that was made very clear.
Yeah.
And he believed that evidence. But I think the real lessons from this are, if you're in, whether it be a Fair Work Commission proceeding or any other kind of negotiation, or you're entering into an NDA with somebody and they indicate that they have a misunderstanding about how that's going to operate and that they feel like they can do things and they represent that to you, if you don't take steps to clarify, then there is a possibility that that person might be able to not have that deed enforced upon them, in terms of it might not be a bar to them bringing proceedings. Added to which, another great lesson from our friends of the Commonwealth in terms of keeping notes and keeping contemporaneous, records of things. So if you are having any of these negotiations, having that extra person to be the record taker or the minute taker, or even frankly just asking, if you are doing it one-on-one, asking for it to be recorded and saying we'll send a copy to everyone so we're all on the same page, that can be absolute gold when you're like, well, we've got the recording, if they've got a copy, we've got a copy, there's no dispute about what was actually said. So I think some really great lessons there in terms of
really helpful case.
Yeah, trying to make sure that you're able to rely on that barter proceedings that we all know that we hopefully are getting in any of these deeds that we're entering into. Last but not least, questions. We've got one right on time.
Quick one, so we might just answer that one before we let everyone get back to their day. So once an investigation is completed, all parties are no longer obligated to observe the confidentiality of the investigation and can discuss what occurred unless an NDA has been signed by the parties. So is that correct? So once an investigation is finalised, everyone can go off and start talking about it? Or
it comes down to this lawful and reasonable direction piece. Would it be a lawful and reasonable direction to stop them, or is it a policy and procedure that you've got in place that says that they can't? I would think without that, in most instances, maybe depending on the context. What's your take?
I think a lot of it would come down to, are people remaining employed with us? So
great point, actually.
If the participants, say for example the allegations are unsubstantiated for whatever reason, all participants remain in the workplace, we would continue to maintain that direction applies, and we have that capacity to enforce that because that person remains our employee. If we've got a situation where one or more of the participants leaves the organisation, whether that's voluntarily or otherwise, our capacity to enforce that direction basically falls away. So that person then, in the absence of some other obligation, does have that capacity to go around and tell people about what happened to them or what they experienced, unless we have an NDA,
something we can rely
a deed
upon.
of release or some other kind of document like that. So good one to kind of tie some of those threads together from a practical perspective. But unfortunately, I think we have to leave it there. So thanks everyone for joining us. Hopefully you found that discussion useful. Watch this space.
Yes, definitely watch for reform.
We'll continue to keep you updated, particularly from our friends in Victoria.
That brings us to an end. We've put up a slide with the ways we can help, but just a reminder, if you are ever needing any assistance with drafting any of these documents, you need a deed of release drafted, you need an NDA, or you just generally need help with the broader issue of sexual harassment, don't hesitate to reach out.
Thanks so much.
Thanks, everyone.